And we're recording. Good morning, everybody. Welcome to the Michigan Professional Firefighters Union Duty of Fair Representation, or DFR, webinar. We're glad you're here this morning with us. One of the nice advantages of doing these webinars is on a really nasty day like today, we can still get together and do a class. I don't know where you're at today, but it's really snowy and miserable where I'm at, so it's a good day to be inside and do a class. Real quick, we'll introduce ourselves. And just so you know, also we are recording this broadcast, so you can watch it on the website down the road, or show other people, or tell other people about it. My name's Sean Abbey. I'm going to be kind of handling the tech today, and dealing with your questions, your chatting, things like that, and being an assistant co-instructor with our lead instructor. I'm the second district vice president on the west side of the state. I serve on the education training committee, and I chair that with Andy, who's going to be your other presenter. And I'm an IFF service rep, and I've been doing those things for over 10 years now. And I'm a member of Kentwood Local 3174, where I've been a member of that local for over 25 years. And I was pretty much everything on the e-board when I was involved with the local there before I was elected to the state. Happy to be here, and hopefully we've dealt with a lot of this kind of stuff, this DFR stuff in our locals and around the state, so hopefully I will have a lot of good information to pass on to you today. This program is going to be very in-depth, and we're going to try to cram as much as we can into this next hour. And with me today is Andy.
Hi, my name is Andy Hood. I'm Education and Training Committee Vice Chair, Harrison Township Local 1737. I've been with the local over 20 plus years, serving in most of the roles of the executive board, mainly as president. Hope we have some good input to offer to you, and looking forward to the webinar today.
So good morning. There I am. Good seeing everybody. There's Andy.
Here I am.
Looking good. All right. So we're gonna kick this thing off here. One thing I do have to, when we're going back and forth here, you'll kind of see our screens. That's just kind of how we get to the main program. We also have Kevin Caldwell joining us. He's new to the Education Training Committee, and it's going to be kind of hopefully one of those guys, up and coming guys, to take over some of this stuff from the old guys like me down the road. So Kevin, you there?
Yeah, I'm here.
All right, Kevin, go ahead.
Good to be here, guys. Thank you.
All right, Kevin's out of Western Wayne, local 1279. We're glad you're here today, Kevin. Really quick, I just want to launch a quick poll. Webinars are something we're trying to get more involved in at the state, just because, like I said earlier, it's nice. We've got a large state with a lot of members across it, and in months like January and February, it's nice to be able to get together still. So we're going to kind of see where you guys are at as far as if you've ever been in one of these webinars, so we kind of see what you guys are doing. There's a poll there. If you can please answer those polls. How many webinars have you participated in? Just select one of the following, and that'll kind of help us kind of gauge the audience a little bit. Just give you a couple seconds to answer that. We had, I think, 25 to 30, 28, I think 28 people signed up. We've only got 11 in the room today, so some people are missing out, but now we might have some people join in. So there you go. Yeah, 86% of you have attended a webinar before, and a few more have attended more than that. And nice thing is, there's no one that's never attended one, so that's good to it's good to see. All right, moving right along. Real quick, I'll cover the ground rules, and I'm going to kind of turn it over to Andy for the class. Raise your hand if something's wrong or if you have something timely. There's a place on the side there where you can raise your hand. Also, you can submit questions. You can literally type in questions, and I'll kind of try to field those and get those to Andy, and we'll answer those as we go. And I try to answer those polls as we go along as well. It kind of keeps everything really it's kind of nice being able to keep you guys as involved as possible. Sometimes, obviously, the downfall of a webinar is you're listening to us talk, but there's not as much interaction. But we want to try and encourage that. So if you can, just submit questions. There's also a chat feature, so you can either chat to like just one of us. You can send us just a direct message, or you can chat with the whole classroom. We'll try to get to those as often as possible. Also, as we go through, we're going to have a question and answer period. We kind of, as we go through, you'll see there's question periods as well. So if you've got a question, you can answer it, or I'm sorry, ask that at that time as well. And we'll take time to answer those. That's pretty much after each topic. Let's go. Now, one thing, so just so you guys know, I'm on this thing here. You can kind of see in the side there, right in this area, you can see where you can submit that stuff. When I click over here, that's when I'm kind of checking for hands and things like that, because I need to be in this. Version to be able to see people. Does anybody got anything to get started? I'm gonna call on Bill. I know you're out there. I'm gonna open up your mic for a second. So this is how it happens. All your mics are closed, but if you want to ask a question, I can open your mic. And Bill, you there?
I'm here. Hopefully you can hear me.
Yep, I can hear you.
Okay.
All right, welcome. Glad you're here.
Thanks.
All right, so yeah, we can turn your mics on. You can answer questions or ask questions, and we'll answer those for you as we go. All right, here we go. Andy, take it away.
All right, so we always start this one with a disclaimer. This class is intended to educate MPFFU members and affiliate officers. It is intended to serve as informal guidance on the matters addressed and should not be relied upon as legal advice. Anyone using the information provided in this program should rely on his or her own independent judgment, or as appropriate, seek the advice of a competent professional in determining the exercise of reasonable care in any given circumstances. The MPFFU disclaims liability for any injury or other damages of any nature whatsoever, directly or indirectly, resulting from the use or reliance on this information provided in this training program. Due to the nature and topic of this course, we'll be going over many slides word for word and discussing further.
And again, it's always prudent to, if you're in a DFR case or duty of fair representation case, obviously, I consult legal.
So the goals and objectives today, we're going to define a duty of fair representation and how it came about, review case law and the impact on how we operate, review strategies to avoid a DFR claim against the local, and review available resources. So let's start with the definition. 3 words: duty, fair representation. Duty is an act or course of action that is required by one person, a service function or a task that is assigned to one. Fair, in accordance with rules or standards, legitimate. And this is kind of important, but without cheating or trying to achieve unjust advantage, and being fair to everybody. And last, representation, the action of speaking or acting on behalf of someone. And an example of that is a body of legislators that serve on behalf of a constituency. And in our case, an executive board that serves on behalf of its members.
We're gonna hit real briefly on this, and I'll hit on this first because I'm gonna let Andy go really in depth on this later. We're gonna talk a lot about this case. But this case in 1967 basically laid down the groundwork for DFR claims, and I really want you to focus on that as you read through that. But I want you to focus on the end, and it says toward a member of the collective bargaining unit, is arbitrary, discriminatory, or in bad faith. So it cannot be any of those 3 things. We're gonna spend a lot of time on that today, and Andy's gonna cover that really well. But this is like the landmark case that kind of really sets the DFR off.
So the origin of where this even came about from is created by the courts. The National Labor Relations Board gives the union exclusive bargaining rights. And what that means is the union has the sole right to represent its members. Early on, companies would choose what unions they wanted to deal with, and not the one that the employees wanted. A single employer could have several unions and many non-union members to negotiate with. So you can see how, from the employer's perspective, that would create a big problem, allow for favoritism of one group or unit over the other. Employers would choose the easiest, which is not always the most popular union. Unions went on strike to be recognized. This sometimes created a bargaining deadlock. One group would be negotiating against the other group with management, and a whole lot of bad things occurred. At the end of the day, it came down to the National Labor Relations Board instituted elections as a means for the majority of the members to choose the union they wanted to represent them. And by doing that, that's what created exclusivity. By statute, this creates a legislature type of situation, kind of like we talked about earlier. Members are the constituents and the voters, and the union officials are elected and must carry out the duties that the membership tells you to do. Legislatures are limited by the Equal Protection Clause of the 14th Amendment. This prohibits any type of discrimination. This goes all the way back to the Civil War, 1868, and continues to provide equal rights for all citizens, and has extended past race to include gender, religion, or disability. This is also the basis for the Brown versus Board of Education decision in 1954, which helped to dismantle racial segregation. And basically prevents, the amendment prevents unreasonable discrimination against any group of citizens.
Any questions on that first section? All right, excellent.
So there's many different DFR claims, but there's really three main areas that unions see when there's a DFR claim raised against the local. First is the grievance procedure. First of all, a union can fall into DFR claim if they fail to process agreements, and that could be even include fail to file in a timely manner and have a default judgment entered in the grievance procedure if your local contract has that language.
It also includes if you fail to take it, or if you proceed in a perfunctory manner. So if you process that grievance and you just don't do due diligence of your duty, that can also affect it. And what's perfunctory? It's that if it's done routinely or with little interest or care. So you just basically brush it under the rug, or basically don't take any real thought or care into that grievance.
Or in general, just you don't take the grievance seriously.
Right, and that's a big one.
In negotiations, one of the places that we see DFR claims is failing to represent members equally. Probably the easiest example here is prevention division versus suppression division. If the majority or all of the members of the bargaining team are in suppression and they fail to negotiate for the needs of the prevention division, they can open themselves up to a DFR claim. You can't discriminate against a particular group. Courts have given unions a lot of leeway, stating that unions need to have the flexibility during bargaining to negotiate a deal. They have, however, ruled for members if there was a blatant discrimination, or if the agreement was against everything the union is trying to accomplish. For example, if the union's main goal is worker safety, and they negotiate to drop staffing and fire prevention to gain something else. So in general, you got to make sure that each group is represented fairly and equally in negotiations. And the last area is contract administration. Interpreting the CBA, the collective bargaining agreement, to discriminate or favor a certain person or group, and ensuring that the CBA is followed by both parties. Make sure to help prevent this, you need to make sure you're doing your duty in the day-to-day operations of the local. This includes making decisions about the collective bargaining agreement. If it's a questionable issue that arises, have the e-board or members assist at a meeting. If it's straightforward, make the decision based on what the collective bargaining agreement says and not what you want it to say. Do not discriminate against any group in your local. You would not agree to drop the seniority provision of your promotional process because that decision adversely affects those with seniority, even though you may be trying to assist members with less seniority. If administration continues to violate the CBA and you do nothing, you're putting yourself and the local at risk of a DFR claim. It's your duty to ensure that the CBA is followed as it was drafted.
And a lot of times I've seen it where people think they're helping out, or maybe the collective bargaining agreement, the way it's drafted, uh, is up for interpretation, and then interpretation and the way it's always been interpreted maybe affects 5 members of the local, but the way you want to interpret it could impact 100 members of the local. So you change to say, oh, I'm going to try to do the most good for the most people, but you can't neglect those 5 people that it's actually intended to impact. So you really, you can get into a sticky situation there. And a lot of times it happens by people are just trying to do the right thing. They think they're doing the right thing, but make sure you just follow that contract. Sorry, Andy, I'm kind of checking everybody here. All right.
Yeah, no problem.
All right, go ahead.
Well, here's a U.S. Supreme Court case, Vacay versus Sipes, 1967. And this is where we really get the guidance for what a DFR claim is. They cited, and let me read this, and I'll go a little bit into the case. There's a breach of statutory duty if fair representation occurs only when a union's conduct towards a member of the collective bargaining agreement is arbitrary, discriminatory, or in bad faith. So there's a little bit of case history on this. An employee was fired for not being physically able to perform his job duties. The union filed a grievance, proceeded through the first 4 steps. Before filing the 5th step, the union sent the member for a physical. The result showed that the employee was not able to perform his duties. The union stopped the grievance process, and the member filed a DFR lawsuit against the union. The Supreme Court ruled in favor of the union because the member did not prove that the union violated any of these 3 areas, arbitrary, discriminatory, or in bad faith. So here's where we get some of the arbitrary standard that we deal with today, ALPA versus O'Neill in 1991. If a union's actions are arbitrary only if, in light of the factual and legal landscape at the time of the union's actions, the union's behavior was so far outside a wide range of reasonableness as to be irrational. In this case, Continental Airlines filed for Chapter 11 bankruptcy. During this process, they cut the pilots' benefits in half. Pilots went on strike for 2 years. During the strike, several pilots crossed the line. To finally settle the dispute and return the pilots back to work, the Airline Pilots Association agreed to a deal that brought its pilots back to work while disposing of all pending litigation. Continental insisted that the scab pilots were to be given the first 100 positions, and the rest would be given back by seniority. The Airline Pilots Association agreed only because the members wanted to end the dispute and ultimately the strike. Several of the striking members sued the Airline Pilots Association that the final agreement was arbitrary and discriminated against the pilots that went on strike. The courts held that the pilots were not further harmed by the settlement because, due to the climate and the bankruptcy, if the union gave up the strike and had not settled, Continental would have most likely given all of the first jobs to the scab pilots before striking pilots. They ruled the union acted well within its wide range of reasonableness required by the DFR.
I think that's key in that too, Andy. When we talk about the take a look at that wide range of reasonableness, that gives you a lot of leeway as a local, and when you're working through any of your issues with management, you have a wide range of reasonableness. Again, I think there's some people I know we talk about. Some people just cannot be reasoned with, but reasonable it's kind of even an interesting word as far as that what that reasonableness is. But if you're reasonable, the courts are going to side with you. You can just prove that you're being reasonable. If you're being irrational or irreasonable, then obviously you're going to have a problem.
And this is important here too. Arbitrary, if you act in an arbitrary manner, which means based on a random choice or personal whim, rather than a reason or system, you are opening yourself up to a DFR claim. And I think that bottom part's the most important, reason or system. If your local has the system in place to deal with grievances, you can, by following that system, eliminate a lot of your DFR claims. For example, my local, if a member has a grievance, brings the grievance to the executive board. The executive board acts, all 4 members act as union stewards. And, they'll present their case and show their evidence, and the executive board will meet and determine if the grievance has merit. If they say no, this grievance doesn't have merit, the member has a right to appeal that decision to the entire membership. And at that point, the membership makes a ruling and says, all right, we believe this grievance has merit or does not have merit, and we go on. But the point is, there's a procedure. So you're taking the choice out of an arbitrary standard and saying, all right, here's how we do it. By following this procedure, we went through all the correct steps, and this is the decision we arrived at, and that'll help eliminate the chance of something being arbitrary.
Yeah, that's a great point, Andy. I love this slide because really what you just brought up and the words personal whim, those two things are probably the reason for over 90% of DFR cases. If you have a system like Andy mentioned and you're not acting on a personal whim, if you take those two things off the table, you're really going to be in good shape and putting your local and yourself in a position to do the right thing. So yeah, that's a good point. All right, we're going to launch another poll question real quick. If you can please take a second. Hope everybody's doing good out there. And just want to know, do fee-paying non-union members have the same representation rights as members, including grievance representation in council? So basically, we just want to see what you think. If you have any fee-paying members, these are people that don't want to belong to the union. Remember, in the state of Michigan, you do not have to belong to a union. However, you do have to be in police and fire anyways, part of your collective bargaining unit. And part of your collective bargaining agreement means that you need to pay some fees. So just everybody take a second real quick. We're almost there. Just want to give another 5 seconds or so. Anybody else? Sorry, I'm losing my mouse. There we go. All right, we'll see what these are. Okay, interesting. So 56% of you say that yes, that they do have representation rights and grievance representation council, and 44% said no, so almost 50-50. And so we're going to hide these and we'll go back. And so, Andy, what do you have to say about that?
Well, I see the ones that voted yes are correct. And that comes as part of exclusivity of the bargaining unit. They pay a fee for contract administration and other union rights up through discharge, discipline, and the grievance procedure.
It's one thing a lot of people, I won't say get wrong, but that's a great way to set yourself for a DFR, and that's exactly what happened in this next case that Andy's going to talk to you about.
And this is exactly how we get into discriminatory. Bowman versus TVA. It is clear, I'm not even going to try to pronounce that word, there is that a union practice that principally looks to union membership or non-union membership to determine the type of representation that will be provided bargaining unit employees is discriminatory. So right there, 1984, the decision was made by the Supreme Court that whether or not you're a member of the local, if you're a member of the bargaining unit, you have to be treated the same. And case history on this, a person by the name of Bowman was discharged by the TVA, Tennessee Valley Authority, in 1979 when he refused to accept a transfer from Chattanooga to Florence. He pursued a grievance procedure on 3 complaints, including one that involved this suit. He was terminated solely because he was not a member of the union. After all the grievances were denied, and he filed this action in the federal district court, naming as defendants his employer, the TVA, and his collective bargaining agents, SPEP and OPEIU. Those are the 2 unions that represented him. In this complaint, Bowman challenged the provision of the collective bargaining agreement, which gives preference to union members over non-union employees. After district courts ruled in favor of the union, citing things like the union's ability to reduce the number of free riders, the U.S. Court of Appeals, Sixth Circuit, overturned their ruling, citing, we conclude that the union preference provision does discriminate unlawfully against Bowman and other members of the bargaining unit who do not belong to the unions. Unions enjoy the position of exclusive representatives of employees in Bowman's classification under a contract which permits members within the unit, regardless of whether an employee has chosen to affiliate with the union. The duty of fair representation under these circumstances prohibited the unions from bargaining for or agreeing to any provision which singles out the employees in the unit who are not union members for being treated differently. So going back all the way to 1984 was when it was determined that regardless of whether or not a member is a member of the bargaining unit, he's entitled to the same treatment.
I thought it was funny how it started in 1979 and it got settled in 1984. So obviously the courts are not any different now than they were then. So it takes a long time to get stuff done. So again, yeah, you can't discriminate based on the fact that they're not, and that's key. And I would say that if you have members that aren't in the union, they're probably some of the people that are a little more I don't want to say savvy about this, but they don't want to belong in the union, so they're going to really hold you to task if you're not, if you're not following the law, and that's how you can really get your local and yourself into hot water. Remember, when you're doing stuff, if you're doing stuff on your own and not acting, if you're acting on behalf of the union but just doing it on your own, you're putting yourself at risk.
And it's kind of funny. We have one of these members in my local. Decided he wanted to be a police officer as well as a firefighter, obviously in violation of the IAFF Constitution and bylaws. Prior to trial boarding him, he was asked to resign from the union, which he did. But as it turns out, that member of the collective or member of the group is probably one who has the most discipline throughout the membership in its entirety, and as a result, has cost the union the most money in the disciplinary process.
Yeah, because he's a cop.
Yep, exactly.
All right. I'll
Right,
hit this one real quick. I'll give you a quick break there, Andy. So
Okay.
just talking about agency shop and fee paying. All this says that you have to pay a set fee for representation and CBA administration only. Keep in mind, there's a guide in your handouts, and mention on that there's a bunch of handouts. There's 5 handouts, so make sure you get those. One of the handouts is this talks about the agency fees and shop fees, and they may attend union meetings. They may not attend union meetings, rather, and may not vote, but they may attend meetings where you're going to be talking about the collective bargaining agreement. So like a vote, because they're paying for that, and they can vote on the CBA. I've heard stuff legally all across the board on this, from the IFF to our own legal counsel here in Michigan to other labor attorneys, and I've heard different answers from all of them. No, I shouldn't say all of them, but a lot of them. But to be safe, they're paying. The one kind of thing they all kind of agreed on or kind of mentioned was they are paying a service fee to maintain the contract and to be able to do it. So because they're doing that, that does give them the right to attend those collective bargaining agreement meetings and to vote on the collective bargaining agreement as long as they're paying that service fee. So it's kind of like that's what they get out of it. But obviously the other stuff they're not going to be a part of.
All right, and last, acting in bad faith. 1994, Lewis versus Tuscan. The union acts in bad faith when it engages in misrepresentation or other deceitful conduct, conceals information. And here's a little bit of case history on this. And basically it means unions have to be upfront with the members. You can't be working back deals or you've got to be open and honest with your membership. Case history, Tuscan Dairy Farmers was in New York and was in the middle of milk industry changes that included plant closings and mergers. The union agreed to unilaterally change the CBA to use entailing and dovetailing when it came to merging union shops without informing its members. This is eventually ruled to be both discriminatory and in bad faith. The court went on to say that the union has a right to make this change as long as the members know their rights and understand the CBA.
Here's another example.
And another example, bad faith, Bennett versus Glass Molders, Local 66, 1992. The union acts in bad faith when it engages in unjustified interference with its members' contract rights. For example, secretly extending the probationary period, as this references here. U.S. Court of Appeals, 7th District, Sherry Bennett was an employee of Owens Brockway Corporation. Upon completion of her 30-day probationary period, she was given her union card and welcomed into the union by the union president, who also told her that there would be no extension of the probationary period. Several days later, union representatives, including the president, met with the company's officials and agreed to extend retroactively Bennett's probation. This purported change in Bennett's status, which no one told her about, allowed the company manager to fire her summarily within a few days. The union then claimed its hands were tied. Since Bennett was now a probationary employee, she was not entitled to the union's protections under the CBA. Bennett sued, alleging the company had breached the labor contract and that the union breached its duty of fair representation. After a bench trial, the district court found in favor of Bennett and awarded her damages. Because the lower court applied the correct legal standards and made no clearly erroneous finding of fact, they affirmed the decision. So in this case, this woman, the union secretly made an agreement related to her acting in bad faith, which ended up in her termination.
And really bad faith really comes from if you don't attend classes like this, if you're not educated and you just do something on a whim, you don't follow your timelines, you don't keep your members informed, things like that. That's really how you find those bad faith things. And again, we've got to have examples of all these things happening across the IFF at certain times. So it's really good that you guys are here today and hearing a lot of this. This is all good information. One thing I think that's interesting in all these court cases Andy was talking about is a lot of them are pretty recent. This isn't like ancient history. I mean, like 3 of these were after I started on the department. So these are all things that are happening. So this isn't ancient history. This is stuff that's been dealt with more recently.
So in your handouts, everybody should have handouts here. If not, did we email those out, Sean? Or
they're right. They can get them right on the GoToWebinar site, or right on
gotcha.
there. They're right. They've got access to them right now.
Gotcha. Click your handout tab. You can see all these different handouts.
Yep.
I think they're all in PDF form. There's a Merck notice. Goolsbee versus Detroit, 1984. Excuse me. This gives the local, or requires 3 distinct responsibilities of your local union. To serve in the interests of all union members without hostility or discrimination towards any one member, to exercise its discretion in complete good faith and honesty, and to avoid arbitrary conduct.
It's interesting because this case is landmark and it's used across the Vega case is like the first one and this is the next one, and that's really puts a big deal of I don't want to say information, but a lot of support of how a DFR case is gonna fall, and it really kind of lays it all out. And it was right here in Michigan, so it's kind of cool.
In this case, AFSCME, AFSCME was processing a grievance that dealt with the City of Detroit sanitation workers. There was a group referred to as the White Wingers that cleaned the streets with white carts and brooms. It was considered light duty in the department. 1973 collective bargaining agreement changed the qualifications of all workers, stating all workers must be able to perform all job duties. The city then insisted all white wingers take physicals, verifying they could perform any duties assigned. Many retired, went out on workman's comp, or stayed on to fight. They filed a grievance stating they did not agree with the city's new policy that they had to be able to perform all work. The union filed the first 3 steps of the grievance procedure and said they were not going to file the 4th, or said they were going to file the 4th, sorry. However, they missed the 15-day deadline and the grievance was dropped under the rules of the CBA. The members then filed suit against AFSCME for duty of fair representation. The Supreme Court, Michigan Supreme Court is where this was settled. They held that PARA, Public Employee Relations Act, implicitly imposes on labor organizations representing public sector employees a duty of fair representation. They said that bad faith conduct is not always required to make out that breach of duty. The conduct prohibited by the duty of fair representation includes impulsive, irrational, or unreasoned conduct, inept conduct undertaken with little care or regard or with indifference to the interests of those affected, failure to exercise discretion, and extreme recklessness or gross negligence. And then absent a reasoned good faith, non-discriminatory decision not to process the grievance, the failure of the labor organization to comply with the collectively bargained grievance procedure timeline constitutes a breach of the duty of fair representation. In this case, the union's inexplicable failure to comply with the grievance procedure time limits indicated inept conduct undertaken with little care or indifference to the interests of the plaintiffs, which could have reasonably been expected to foreclose plaintiffs from pursuing their grievance. As a result, the union breached its duty of fair representation to the plaintiffs, and the union was found guilty.
And again, that's kind of a clear. Oops, I'm sorry. Go ahead, Andy.
Oh no, go ahead. This one goes right back to inept duty. They let the timelines go by instead of following the timelines, which would have been very simple to do. Somehow they let it go by. It brought about this entire DFR claim, and the union was found guilty of violating their duty of fair representation to these members.
Oops. All right, again, another poll question. Anybody have any questions out there? We're going to look at your hands now. All right. This is our last poll question of the day. If a member files a legitimate grievance, should they expect the local will process all the way to the grievance arbitration? So you get a member, they file a grievance, and what kind of expectation should they have? Should they expect that to go all the way to grievance arbitration every single time? Just give you a quick second to vote, please.
Yeah, this is a good question. This has very strong opinions in a lot of locals.
Yeah, definitely. And this right here, this is a couple of these poll questions are really the reason why I'm sure a lot of you are here, because these kind of questions are kind of good. So we're going to close the polls. Got almost everybody there. So here you go. 33% of you, a third of you said yes, that they should process all the way through grievance arbitration, and 2/3 said no. So what do we have to say about that, Andy?
2/3 of us got this one right. So, Low versus Hotel and Restaurant Employees Union Local 705. The union as a whole becomes before any single union member, even at the price of a member's interest. The union is vested with discretion and permits it to weigh the following: amount at stake, likelihood of success, cost, and the desirability of winning an award. So there's case law here in Michigan related to this. Because this is from the Michigan Supreme Court, because a union owes a duty of fair representation towards the entire membership when processing grievances, the union is vested with discretion, which permits it to weigh the burden upon contractual grievance machinery. And this, I'm sorry, this is a direct quote, so it's very wordy. The amount at stake, the likelihood of success, the cost, even desirability of winning the award against those considerations which affect the membership as a whole. Therefore, an individual member does not have the right to demand that his or her grievance be pressed on, and the union does not have the duty to carry each grievance to the highest level. While keeping in mind the duty of fair representation, the union ultimately has full discretion as to do with each member's grievance. So basically what this case says, and this is a settled case law for decades, that the union is not required to take a grievance to arbitration, even if it potentially could be a winner. There's other factors that go into that: cost, desirability of success, or desirability of even winning the award. An example here, this is just something that I thought of potentially could arise in my local or another local, but a member gets disciplined for using sick leave to work a side job. Contractual right to sick leave is ambiguous, and the member files a grievance because he's disciplined because of it. The desirability of winning an award and having the union say, yes, we can use sick leave to go work a side job, probably is outweighed by the interest of the membership at whole in that case.
And again, these four things are really crucial, and they really should be, these should be 4 bullet points in every grievance committee meeting. So if you're having a grievance committee meeting to weigh out the justification of processing a grievance, you should be talking about the amount at stake. A lot of people, they dismiss that, but if you're local, no matter what size of local, processing grievance can be expensive, and if you're, it's just one of those things. The amount at stake is the amount of money, and what you're going to win with a potential takeaway. Now, is it something where somebody to get paid one time for one thing, and it's a $10 loss, and they said that they agree that they're not going to do it again, and you're going to take a $5,000 grievance to win $10, or is it something where it's a $10 thing, but they've said they're not going to pay it ever again, so it's $10 times every member times every occurrence. So it could be over the length of your local could be tens, if not hundreds of thousands of dollars. So it's just amount of stake and all that. So really have these conversations. And the key here is to know that you can have these conversations. I've been in places before and they're like, well, we're going to seem weak if our attorney said we're not going to succeed, but we really feel we owe it to this person. We don't want to have a DFR case. We should really go forward with it, and we don't want to appear weak. Well, there's a couple big things there. One, your attorney says it's probably not, there's not a good likelihood of success. Two, you don't have to worry about a DFR case. This case right here talks about it. If you don't think there's a likelihood of success, you can say our attorney thinks this is a loser. And at the end of the day, I would rather withdraw a losing grievance before it's processed than take it all the way through arbitration and then lose. Then you really look weak. So it's really important to have these conversations and understand that it isn't a mandatory thing. So I'm going to open up real quick for questions if anyone has, because this is kind of a big thing. You got a question here? Let me look at this real quick where we're going.
And Sean hit on a real good point there. If you have a marginal grievance like that, get your lawyer involved early. You can save yourself by an hour's consultation fee with your lawyer at $150 or whatever it is. You could save yourself a lot of time and energy when he says, yeah, no, this is a piece of shit. We're not going to deal with it.
Right. So Rick's got a good question. He says, if the union does not want to go to arbitration, shouldn't the union member be allowed to follow arbitration on his or her own? That is a good thing. If you do not want to, at some point the grievance is owned by the local, but the local does not want to pursue it and the grievant wants to, then for sure they can. Yeah, it's kind of a gray area. A lot of people don't want to deal with that part of it. But here's the thing: at some point, the local still needs to kind of be involved with that, even if they're not going to be paying for that whole thing, because what happens is the grievance, the local still has a dog in the fight, if you will, and as far as how that's processed and how that goes. So that's definitely something. It doesn't happen a lot, but occasionally people do want to do that. So, and that can be an issue.
And your lawyer is a good asset for that case as well. Maybe they can talk reason into a person. So back to Vacay versus Sipes, 1967. Though we accept the proposition that a union may not arbitrarily ignore a meritorious grievance or process it in a perfunctory fashion, we do not agree that the individual employee has an absolute right to have his grievance taken to arbitration, regardless of the provisions of the applicable collective bargaining agreement. So they're just reinforcing again where the U.S. Supreme Court, where we get the conversation we just had, where the union is not required to take every grievance to arbitration.
All right, just checking in again if anyone has a question or anything. All right, everybody doing good? All right.
A handful of cases here, and these are discussed a little more in depth in the IAFF's DFR manual that's included in your handouts. Something you should download and have as a union officer. Faust versus Electrical Workers, IBEW. The union discretion is essential in the proper functioning of the collective bargaining system. Self versus Teamsters. Courts have held that a union does not have a duty to process a grievance if the chances of success are only slight. Motor coach employees versus Lockridge. adduce substantial evidence of discrimination that is intentional, severe, and unrelated to legitimate union objectives. And Harris versus Schwimmerman Trucking Company. Schwimmerman Trucking Company.
I like
Nothing less
Schwimmerman.
than a, I sometimes throw extra letters in.
Yeah.
Nothing less than a demonstration that the union acted with reckless disregard for the employee's rights or was grossly deficient in its conduct. And these are just, a couple sentences picked out of each of those that kind of help substantiate where we're at with this presentation today. And again, look through the DFR manual. There's a lot of good information in there.
So really, we've talked a lot about kind of where we've come from, and I hope you've gotten a couple things. One, you should know at this point that you do have to process everything professionally, equally, have the process in place. Everybody knows what that is. Have some kind of system, and on the other side of that too, the courts have given you a lot of leeway on your performance and execution of administering the collective bargaining agreement in regards to DFR, as long as you're doing it by the book. You're not going, I mean, you really should get at this point that if you're using common sense, using the system, you're going to be okay. And they still give you a lot of leeway with things like if there's a chance, a high rate of success, then you should process. If there's a low rate of success, you don't. The cost, all that kind of stuff. So really, now we're going to shift into how you can prevent a DFR claim. So really, these court cases should have kind of shown you kind of where the courts have led us. And then we're going to give you some information on what you can do in your local to kind of make sure that you keep out of that DFR. And then we'll kind of take this home and finish this thing out.
So going back to some of the other points that were made earlier, when you process a grievance, first of all, I'd say have a procedure in place, whether it's written, unwritten. Make sure all your members know it, so that if there is a grievance, they know how to do it, and they know how to follow the procedure. And when your grievance committee considers a grievance, first thing they need to do is consider the merits of the grievance. That's first and foremost key. If someone wants to file a grievance because they got 6 days of vacation and the contract says they get 7, well, there's probably merit to the grievance. But if they want an extra day of vacation, it's really not a grievance. The monetary value of the claim. There's not going to be very many locals who arbitrate a case for a $12 claim for a one-time thing. That's probably, sorry about your luck. Yeah, you're entitled to the $10 for whatever the situation may be. We'll address this in our negotiations next time. The effect of the breach on the employee. Again, that goes back to a very similar conversation, the money, the value. What was the problem? Did the guy lose 48 hours of vacation time? That's probably is something a little more to consider versus a $10 loss. And the likelihood of success in arbitration. If you've got a case that you're not going to win, you really don't need to process a grievance on that. Go through your process, your internal process, but if you're not going to win it in arbitration, it's probably not a good grievance to take.
And that's a good time to really be, truthful with your member, the grievant. If they bring a grievance to you and you've run it by your legal and you as a board, you say, yeah, we're not going to win this, but you see the person's point. You say, hey, yeah, we can see that this is potential grievance here. We just don't think we're going to win it. You can still run the grievance, but just be forthcoming with that member right at the beginning. Say, okay, we've researched this. We've got all our information. We've talked to our attorney. They don't think we can win this. They said we can't win this in arbitration, but we're still going to run the grievance through the first few steps to see if maybe we can get management to, back down or at least come our way a little bit. But just so you know, once it gets to that final step, we don't know at this point if we're going to be able to take it all the way to arbitration from what we're seeing at this point. So it's just really important to be truthful and have those conversations with them. The more information they get, a lot of times I hear stuff where the grievant it's gone through 4 steps or whatever, and they've never even talked to the grievant. And that kind of, you can do a lot by just keeping your members informed. And even if you're not going to go all the way with it to arbitration, they might feel better about it just because you've kept them in the loop going through. And we'll talk about that a little bit as we go forward.
And, steps to avoid a DFR claim. Represent all members equally. That's not members of your local. That's members of your bargaining unit. Document all meetings and discussions related to grievances, negotiation, and contract administration. My local, whenever we have a grievance or potential grievance, they start a folder. They pull out a folder, put all the information in there, it gets a name, and if it gets to a grievance, it actually gets a number. But document everything so that if there's ever an issue, your local can pull that folder out, or electronically, however you decide to keep data, you can look at that and have backup information.
That's a good time to plug. That's a good time to plug our representing members webinar coming in March. Yeah, we're going to be doing something that's going to talk a lot about that, guys. If you're looking at representing your members, we're doing another webinar in March. The date will be coming up, but it talks about a lot about the stuff Andy's talked about the actual physically how you do it.
Follow procedures outlined in your CBA, your bylaws, and your policies. Some locals have very strong language in their collective bargaining agreement about timelines. If you fail to follow that timeline and the grievance is dropped automatically, you're probably in violation of and subject to DFR claim if there's a legitimate grievance. Some locals have strong constitution and bylaws and policies on how to process grievances, some not so much. You should take some time and review those constitution and bylaws and your policies and get something firm in place. Make sure all your members know it, and whether you got to hang it on a union board or give it to everybody a shift change or whatever you got to do, make sure they know the rules and the timelines for filing and following through with the grievance. And then represent your entire membership during negotiations. Don't pick out or segregate groups or based on seniority, based on job assignment, anything like that. We did have one instance where tiers played a role in representing the entire membership. Years ago, a tier was made for a certain benefit, and it resulted in any new hire getting a lesser elimination of an incentive or something along those lines. So some of our members thought, well, as the members with that kept retiring and kept getting replaced by new members who didn't have that benefit, well, hey, we've only got 2 guys left with this benefit. Why don't we offer that up in exchange to get something else? And right there, the membership was talking about opening ourselves up to a DFR claim because we're not representing the entire membership equally. We're picking and choosing, taking something from one group and giving it to another group. Avoiding a DFR claim with grievances. Establish a grievance committee and an objective processing procedure. That can be different for every local. And I discussed earlier how my local does it. But make sure that there's appeals, ways to appeal that if the grievant does not agree with the decision of your grievance committee or whatever procedure you have in place. Merit of the grievance, not the grievant. If it's someone that's always complaining, and 99% of the time they're complaining about nothing, if you discount them that 1% of the time when they have a legitimate grievance, you can open yourself up to a DFR claim. Conflicting grievance. This situation could arise where you have 2 people alleging 2 different things. At that point, related to the same issue. At that point, you've got to look at the collective bargaining agreement, uphold the collective bargaining agreement regardless of which one feels differently about it. Make sure you have a good attitude.
I had that with a Independence Day. I had a local at Independence Day in their contract, and that year Independence Day fell on a Sunday. So if you looked at the calendar, it said Independence Day observed on Monday. So the guys working on Monday wanted the pay, and then the guys actually working on the 4th of July wanted the flip pay. So that was there's conflicting people, and they were like, one was saying, well, if you're going to give it to them, we're going to grieve it. Another was saying the other. So at the end of the day, they figured it out. But that next contract, it said July 4th.
Yeah, there's a very good example. Make sure you have a proper attitude, right? If you're dismissive to someone who's talking to you about a grievance, right then you're making an adversarial relationship when you don't need to, and you shouldn't be. You should have a good attitude, talk to this person about it, even if you've dealt with that issue before and you know they're wrong on it. If this is the 5th person to bring you the same issue, still talk to them, make sure you explain yourself to them, and do it with a good attitude. If you're ever in doubt, just file the grievance. It's easy enough to withdraw. Preserve your timelines. Some places like my local, we can ask for an extension. Our executive board can go to the first step and say, hey, fire chief, we have this issue. We're researching a grievance. Something occurred on this date. We'd like a 2-week extension to research the issue further and get that in writing, put it in the file. So now you have an extended timeline. Or if he says no, just hand him the grievance and say, we're going to continue working on this. Inform membership of the procedure. Again, this goes back to having a procedure and making sure your membership knows it. Follow the same process every single time. That's going to eliminate a lot of the arbitrary arguments right there. Same process. There's nothing that's done on a whim. We get the grievance, we create a file, we meet, we discuss it, whatever your procedure may be or your process may be. Keep the grievant informed. Make sure they know what's going on. Keep them in the loop. Make sure there's an appeals process. Have a grievance form. This is something that your local can do. Make this the first sheet or tape this to the cover of the folder. Have your grievance form with their timelines and where everything's at. So if you pull your folder out, all you got to do is look at the front of it. It's taped on the front. All right, grievance occurred on this date. Date to file grievance is this. Step 2 here, make sure you can keep your timelines that way. And then last but not least, good record keeping of evidence, however you decide to do that. Make sure you keep records, keep all the documentation, and keep it in there.
I just want to hit on this real quick, Andy. So this case, you can read more about it. I think it's in your handouts, but really just said that non-members paying a service fee is constitutional because it creates labor peace. And really this has a lot to do with right to work and all that kind of stuff. This prevent free riding, and the Supreme Court's constantly being asked to overturn this and look at this as far as the right to work type of law. But let's briefly hit that, and we'll go on more of that here in a second.
So this last case Sean was talking about, Abood versus Detroit, was decided in 1977. Louis Abood objected to the union membership and union's endorsement of political candidates. He was trying to overturn Michigan's authorized agency shop agreements for public employees. Basically, the court agreed with the union and upheld fees for collective bargaining, but agreed they should not be used to circumvent free speech and used for political action. Now, this is a 1977 case, and I think Sean's going to talk a little bit later about a California case that was heard in the Supreme Court just last year about the same thing.
Yep, correct. And as we talk, this stuff's always under attack, and there's 2 of them right now. Is this Harris versus Quinn? This is right out of Illinois. And to kid on time, I don't want to spend a lot of time on this one, but I just kind of want to hit it really quickly. But this was had to do with a in-home healthcare provider, and they had like a state union that covered these in-home healthcare providers, and they did not want to pay a fee, and she went out, and this actually the ruling they kind of made it really kind of clear as mud because they said in this particular case that they understood and they kind of agreed. But overall, with public employees, they didn't agree. So it kind of opened the door for further rulings regarding all public employees and if they are required to pay a fee. And really, the big thing is this is all political. It's just as we see the courts swing and sway, it's going to be eventually to a point where I'm sure they'll take another run at it here with the new president, and depending on what court appointees he puts in to try to make it so nationwide. There's basically nationwide right to work for public employees, which would include fire. That's really kind of their end game. And that goes to speaks. Here was their closest attempt with other public employees, which was the teachers. The U.S. Supreme Court heard this case, and this had to do with a teacher in California. There's actually 10 of them, and they formed this group called the Christian Education Association. And they wanted basically the Supreme Court to overturn the Abood Detroit Board of Education ruling. And this kind of went in. Rebecca Fredericks is the main plaintiff. She's a 28-year elementary school teacher near Anaheim and an outspoken union opponent. which I always like. People are outspoken union opponents. It's like, okay, if we didn't have unions, what would we? I mean, you just want to go back to like horrible working conditions or what? But the Supreme Court had a huge blow with the death of Justice Scalia, and that kind of pushed the court into a gridlock, which ruled when it was heard, put the ruling in favor of the Teachers Association. So the national right to work and all that kind of they failed. They thought they were going to have a positive ruling there, but with Justice Scalia passing away, it didn't go that way. So this was to challenge those public unions from collecting fees. So it was kind of so you can see just in these two cases, it's constantly under attack. They constantly want to make us different.
And to touch on what Sean said there, this really hinges on the presidential election, right? Regardless of whether you're a Trump supporter or a Clinton supporter, those people who got elected, in this case Trump, is going to make a Supreme Court nomination. And I think most reasonable people would say President Trump's going to make a conservative appointment, whereas Hillary Clinton would have made a more liberal appointment. So this case, based on who we voted elected president, can be overturned. And here's a number of other resources you can get to help you with these types of things. Other local leaders. You've all probably got locals that are close to you that you talk to. They're a good source. They may have been through this before. Your state union district vice president. Sean's a great resource. He's been district vice president for a long time, dealt with a lot of these issues, and the district vice presidents all meet and they talk a lot about current issues. So even a newer district vice president can, if they don't have the answer, they can look to another district vice president and help with that. IAFF VP Sanders. Your legal counsel is a very good place. MPFFU legal counsel, local legal counsel, or even the IAFF legal counsel. When I was union president, I looked to them for the IAFF for advice on fair share, generally through DVP Huffnagel at the time, but he referred me to the IAFF's legal counsel, and I talked to them a bit about that and other issues. IAFF DFR manual. That's again in your handouts. Make sure you download that. A very good source of information, and even the internet. If you Google duty of fair representation, you'll get thousands of hits. A lot of it will be opinion, and you have to sift through that. But there's a good resource there as well.
And if you hear that term, DFR, duty for representation, or even if you hear one of your members say something like, well, I'm going to get an attorney because I don't think this was done properly or done correctly or whatever, that's a red flag that you should definitely be looking outside to rally your team and get your resources ready so that you can defend yourself. One thing we didn't talk about, I want to hit as we close, is make sure no matter what you do not do anything alone. Never make a decision or anything without talking to other members of your local. So the best part is to have a process like Andy talked about, but at the very least do something. But you do not want to ever have somebody come to you, that person that Andy was talking about that always is complaining, and you dismiss them, because guess what? In that claim, it might be your IFF local, but it might also be you. They can name you in these legal cases as well if they say you're the one that didn't follow the process. So you could be named in that suit, and who really wants to have that happen? So that's our final pitch kind of on that. We do have a couple more slides, but I do want to open up for final questions. Does anybody have anything they want to talk about? You can just raise your hand now. I'm looking at that. If anyone has anything that they did not hear today that they wanted to, or we didn't cover something you were hoping we would talk about. There are two other classes that can go along with this class, and that would be the members' rights course as well as the representing members course. So these kind of all three go together, and they kind of all intertwine a little bit. But if you're looking for more information on representing members or members' rights, hit one of those as well. We also have some of our past webinars on our website, so you can go on there and check those out as well. And like we said, this one's going to be recorded and will be put up there as well. We talked about knowledge is power. We have MPFFU webinars on March 22nd. One's going to be union leadership, and another one's going to be called representing members. Look for that information. It should be coming out shortly. And then there's also an IFF MPFFU union seminar, which will include a lot of stuff on managing your local and how to represent members, as well as union negotiations. And that's May 22nd and 23rd. And more information will be coming out on that as well. So make sure you kind of save the date in if you would like to attend those. Very good conferences. In closing, there's going to be a survey, so please take that survey and let us know how things went. If there's anything we can do to make your experience better. I know this course, this DFR course, we kind of want to make it it's legal, so I know that can be a little dry compared to some stuff, but it's really important to know what cases and what things kind of brought about where we are today. And also make sure you, like Andy just alluded to, download those handouts, because there's a lot of good information in there as well, and a lot of stuff that we've talked about. There is a presentation there similar to this one. This one would not download for some reason, so it's an older version, but it still has all the same information. Just some of the names might be different, but there's a lot of good information in there as well. Our emails are up there if you'd like those. You can email Andy or I if you have any other questions as we go forward. But we really appreciate your time today, and hope you picked up some good things. And I'll look one last time, see if anybody has anything for questions. And anybody have anything else before we close this out? Well, thank you for being here today, and thanks, Andy.
Yeah, thank you very much.
Good work, and we look forward to seeing you guys in another one of these webinars or a seminar. And we've got another one this afternoon on, I believe it's on negotiations, basic negotiations. So hopefully we'll see you at one of those. Take care. Have a great day.
Have a good day.
All right. See ya. Thank you. You still there, Andy?
Yep, still here.
Okay. I'll see you in a couple hours.
All right, talk to you. See you, Kevin.
Okay.
I see you guys later.
All right. Talk to you soon.
Yep, bye.
All right, bye.